And welcome back, everybody. I am again Graham Dodge, or still am Graham Dodge from Magic. And this is the Business Risks 2020 conference. It wouldn't be a live event without some sort of mix-up. And for our next panel discussion, our moderator, Joanne Hovis from CTC Technology and Energy, unfortunately could not make it with us. We have brought in the reserves, and we have Dr. Robert Wack, who you met earlier in our healthcare discussion as the moderator, will be moderating this discussion. So the man who needs no introduction, because I've already introduced him once today, is Dr. Robert Wack. Take it away, Robert.
Thank you, Graham, and thank you for panelists with joining us today. I'm going to do some brief introductions, then I'll give you guys a couple minutes to expand on that, and then we'll dive right into the discussion. So today we have Roselle Safran. She is a cybersecurity professional and thought leader with, and also is the founder and principal of several cybersecurity startups, most recently Key Caliber. She also served as the cybersecurity operations branch chief in the Obama White House, and then before that, in the Department of Homeland Security in the digital analytics branch. So thank you for joining us, Roselle. Paul McGurkin is a partner with Mullen Coughlin LLC. Mr. McGurkin focuses exclusively on assisting clients to prepare for and respond to data security incidents and breaches, including regulatory investigations and inquiries. Mr. McGurkin has experience advising clients on compliance with state, federal, and international privacy and data security laws, particularly those involving protected health information and personally identifiable information. Mr. McGurkin also assists after data security incidents in helping clients determine the applicable laws that govern their notice obligations and ensuring compliance with such obligations. And then last, certainly not least, is Mr. John Wack, my cousin. He is a cybersecurity professional who works with Prometheus Computing on election security, and prior to that had a long career with the National Institutes of Standards and Technology, where he worked on computer and network security since the very beginnings of the internet. He is the author of several early publications on managing the risks from computer viruses and worms. So thank you, everybody, for joining us today. And I'm going to jump right into things. So the first question is, we've had several discussions so far in the conference about just the state of the world in cybersecurity and how it impacts businesses. And the consensus so far, to put it concisely, is that it's pretty much the Wild West, and that there's some general frameworks that are emerging, but the reality is that there are way more questions than there are definitive answers about best practices, liability, insurance, and then the financial implications of breaches. So the first question to you guys, and I'll just throw it out there, is, as you are looking at assessing your risks and liability in your businesses or in your practice, in your case, Paul, where do you look for guidance? Like, what are your sort of guide stars that when you have a question, it's like, I'm going to check with this source, this agency, this body for standards. So Roselle, I'll put it to you first. Where do you go?
Sure. Well, so I've been in the field for many years, so some of it just comes naturally, especially when it comes to how we are protecting our network, our product, and how we're just operating on a regular basis. But we do also keep tabs on NIST CSF, because that's, for many people, the framework that's used as a starting point. And now we're getting into an interesting phase with our company where, so Key Caliber is less than a year old. We launched in December of last year, but we are now getting set to deploy with our first Fortune 1000 financial services company. And with that said, we have to adhere to their requirements. And it's been actually fascinating for me to see how much customer requirements have changed in the last 5 years. So with my last startup in, say, 2015, 2016, we'd be working through the master services agreement. There was some covering of information security, cybersecurity controls and whatnot. But today, like fast forward to 5 years from then, and I'd say about a third of the agreement is related strictly to the security controls and handling confidential information. So that's been a big change. And realistically, at the end of the day, we have to adhere to what our customers demand of us. And we have a tiny bit of wiggle room with that, but not a ton. I mean, maybe we can adjust the cyber insurance values from 2 million in aggregate to 1 million in aggregate, but there's not too much leeway with it. And so even though we are a tiny company, we're finding that we're going to have to act like the big leagues when it comes to our security controls, which is fine for us because we're a cybersecurity company, and I was planning to do that anyway. But it mandates it in a way that is different from 5 years ago.
So that's a great lead into this, because that is really one of the founding or the driving things for this entire conference was the experience that some of our members in Magic have experienced with that exact thing, that they're out there selling services to larger companies who then hit them over the head with these crazy onerous requirements for information security, some of which weren't even relevant to their particular business. And so that raised this question of where do these things come from? So Paul and John, I would put it to you. Roselle has framed this as, as a small business owner, the scope of her liability and her performance measures are being driven by customer requirements. Where are those customer requirements coming from? What's driving them to put this into the contractual language, I would imagine, that says Roselle's company has to do X, Y, and Z? Where do you guys think those things are coming from?
So from a legal perspective, I think it's twofold. Right? I think the first is the notification statute. So, but all 50 states, Puerto Rico, DC, Virgin Islands, all have their own notification statutes, and it's there. So there's certain things that are required there, actions that the laws require that the various entities take. And there's also, when you get into at the federal level, specific requirements, like for hospitals, I'm sure we're all familiar with HIPAA. When we go into our doctor and sign the forms, there's certain requirements that are done there, and certain other entities like the GLBA, Glam Leach Bliley, requiring of financial institutions and those that kind of live in that world. And the second big bucket is frankly life experience, right? So when an entity has a problem with a downstream vendor, then maybe the vendor has a breach and it takes them 3 months, 6 months to tell the entity. The next round of contract is going to say, you have to let us know in a week. You have to let us know in 2 weeks, because that, then just because the vendor did it, you are, in most legal contexts, as well as kind of viewed by the public, you're beholden to your vendor, right? You chose to work with them. So the excuse to a state regulator or to a customer is not, well, they didn't tell us for 6 months. It's you're responsible for doing them. So they learn by peers that do it or prior experiences that say, you need to let us know in a week, 2 weeks. So I would say kind of learning through past examples, number one, and number two would be the state laws and federal laws if it's applicable to that industry.
John, what do you think?
Life experience, like Paul suggested, and I think coming from the National Institute of Standards and Technology background, a fair amount of I'd say regulations, requirements, or just due diligence seems to come from NIST, really from way back. I think in 1987, there was a Computer Security Act passed. And at that particular point, there was some move towards NSA actually directing computer security for the federal government, and it was split into NIST and NSA. and that gave NIST more power, and NIST naturally started issuing some documentation and regulations, and other things came along. There was an E-Government Act of 2002 that promoted more involvement from NIST, and it goes on and on. I'm reading off of a couple of items here. There was a Federal Information Security Management Act some years back, 2002, FISMA, that provided a kind of a baseline set of security controls. And a lot of this stuff migrated towards contractors to the federal government. And also some businesses in this particular area would advertise that they're compliant with this particular specification or this particular set of controls. And there's been some industry acceptance, or a large amount of industry acceptance, of these sorts of controls coming out of NIST, and more industry involvement in it. So a lot of it comes from there, in my opinion. But also, like Paul was saying as well, just in legal areas, just due diligence sorts of practices that you need to observe in case something goes really wrong for you.
Okay. Paul, is there, so when there's an issue and something, is being litigated, certainly these regulations and guidelines are going to be a factor, but then there's also precedent, that how similar cases were ruled on in the past. Is there any case law so far, or is there enough case law in cybersecurity conflicts that there are precedents that are looked at now and cited as, well, this is how this court ruled on this particular thing, and your situation is very similar to that, so here's what you should do. Have we gotten to that point yet, or is it still too early?
It's still too early. I mean, you can try to adopt from other areas, it could, like standard of negligence or things like that, that if an industry standard is X, whether it's, in manufacturing and trying to adopt that, but overall, not really. I mean, these laws are very much in their infancy in terms of kind of the life cycle of how long they've been around. So most of the time, candidly, that we speak to the state AG's office quite regularly in the various offices, and we say, okay, by XYZ, what do you mean? And they say, we don't know. And there's no case law there. So I kind of have to do your best and say, well, you're talking to Massachusetts, and you say, well, Vermont told us this, and like, that makes sense. All right, we'll go with that. So it's a bit of kind of trying to figure out as you go and trying to get those communications down. So it's very difficult specifically to say to that communication. I'm on the phone with a client that says XYZ, especially in the dispute when you're talking business to business, right? A violation of a contract. Did what they do, was that appropriate? So it's very much there in this context. Really, just have to try to adopt from a different line of case law to say kind of what a standard would be.
So do you see that a lot of this is being driven by at the state level as opposed to the federal level, that these things are all being resolved in state courts?
Most of I think so. It's the state laws, I think, is done. Outside of the hospital world, OCR is one that enforces HIPAA, and unfortunately, they are so powerful that, in terms of they can just launch under the laws that enable them under HIPAA, you can audit like a hospital or medical provider at any time from top to bottom. So they want to stay off the radar. So if it's a matter of paying a small fine to stay off the radar, they're happy to do it. But otherwise, it's really driven by state laws.
Got it. Okay. So following on that, Roselle mentioned that when she's talking to clients, that a lot of her stuff is being driven by contractual language, and that came up quite often in earlier conversations. That because there's this sort of murkiness about it, that the consensus from the panels and some of the speakers was that the main way businesses can protect themselves and bring some order to their lives in relative to cybersecurity is through contracts, through language in contracts that you generate and contracts that you sign, and making sure that you're crystal clear about what those contracts specify and what it means and what obligations they create. What do you guys think about that?
Well, at the end of the day, no matter what other company you're interacting with, you're going to have some sort of contractual agreement. And as much as it's quite burdensome for a little startup. I do fully understand the concern and the need for that. I mean, if you look at what percentage of major breaches over the last few years have been the result of a small third-party vendor being the initial attack vector in, it's logical for the large company to insist that the smaller companies that it's doing business with are meeting some kind of standard. And so it makes sense. And in reality, it doesn't matter like what size of a company you are. Attackers are plenty happy to go after the little guys, especially if you are connected to a bigger fish. So it's in my mind, from the standpoint of a practitioner, I think it makes sense, and I'm all for it. From the standpoint of being on the other end and having to meet all the compliance, it's tough. I'm not gonna sugarcoat that in any way, but I think it's absolutely necessary, and we were gonna do all of it anyway. There was nothing in there that was so outlandish that we said, oh, this doesn't make any sense. So yeah, it's part of the cost of doing business these days. And in a way, I'm glad to see that there is this focus on cybersecurity, because 10 years ago, there wasn't. And as a society, we do need to adapt to the fact that cyber attacks are a major issue, and that's not going away anytime soon.
John, anything to add to that?
Oh, I would say, well, I tend to think that basically the better structured you are as a smaller business, assuming that larger businesses have a better handle on this, the better you're able to incorporate good computer security practices into your operations in more cost-effective ways, and in ways that actually support the mission of your organization, and you're also just more resilient to issues that may like a ransomware attack or something of that sort, if you're prepared for something like that. I think one of the problems, the way I perceived it, is that it's difficult for people who don't have a background in this area to acquire that sort of a framework, that initial knowledge. And when you were talking about writing things into contracts, we have to know, what to write into the contract to some extent.
You're anticipating my next question.
Do you want to go ahead and ask that? No. I'll finish, or?
Sure. So, Roselle, you are in a uniquely, an excellent position to be able to assess what a customer is imposing upon you. Like, is that reasonable? That's excessive. And you're probably the best situated to have that negotiation. But many other small businesses, especially that are, maybe not directly in technology, but sort of technology adjacent, but they still touch sensitive data and, are still maybe subject to these sorts of requirements, but they have no idea whether this requirement that big customer X is saying they need to comply with, these various certifications and whatnot. So what sorts of resources, and Paul, you might be a good place to start for this. What sorts of resources could maybe a non-tech proficient small business who still needs to do this stuff, where can they go for guidance as to, okay, do I really need to do this? I mean, is this something I should fight, or is this something I just need to suck it up as the cost of doing business in the 21st century?
Yeah, I think first of all, it's can you meet that standard, right? Unfortunately, we find out a lot that the contracts people sign are not done, especially even for a medium size that has like a compliance officer, a privacy officer, or even a legal department, that unfortunately it's done outside of that. So just making sure that the contracts, number one, are done through a standard body and not just salespeople that are saying, I'm going to get this bonus if I close this deal. Sure, I'll agree to anything. And unfortunately, that happens all the time, for small and medium sized businesses. as well, and sometimes large. Right? So I'd say that the other one would be kind of a trade association, would be somewhere I usually tell my clients to start. So even if you are, one person solo CPA or to a medium-sized business, a trade association is a good way to start, because if you are a one-person CPA dealing with that, or you're a school district dealing with a standard, I'm sure your peers are doing as well. So talk to them, talk to your peers, and those would be really the ways I would start, kind of a trade association, or talk to your colleagues, that you would now go into virtual conferences and you used to go over, but I would say those would be the place to start.
Yeah, and SANS is actually a pretty good spot for some of that information too, especially if you need templates for some of the documentation. You want a template for an incident response plan or a disaster recovery plan. It can just help get you moving along in the right direction with some of that.
Yeah, and it just occurred to me, like, maybe this is an emerging business here, compliance as a service. Like, hey, you need help with compliance? Because it's not necessarily legal, although it shades into legal, but it's certainly technical, and you got to be up to speed on all the different standards. So,
and that's another one, Robert, made me think, is that if you do have, say, cyber insurance or even just regular E&O or property insurance, talk to your broker or carrier, because it's becoming much more common for carriers to offer those types of services, where it is something like a tabletop, which is a simulated event, and carriers are increasingly picking that up. Being foresight, because as they're getting more claims, if they can teach a small business to avoid a lot of this, it's, claims are not going to have to pay out. So another thing to think about would be carriers or brokers about, opportunity for sometimes free programs, or at least pre-vetted services that they give you certain programs there.
I'll add in too that NIST does have some resources available if you're a relatively small business or you're just kind of starting from scratch. One in particular I like a lot is about 2 or 3 years old. It's an introduction to information security, but it, even for a very small business, lays out a number of different roles you would like to maintain in your organization, even if they're only done by the same person or maybe 1 or 2 people, as well as basic structure, definitions of terms, why you would want to do certain things, what you need to look out for when you're looking at other products and certifications listed on products and things of that sort. So I think those are very good. The other thing I'll add in too is when you're looking for basic resources is I happen to read the New York Times and the Washington Post, and both of them have sections dedicated to information management, not specifically information security, but information management in general. And the two are so intertwined. So I think those are excellent resources as well. I'll throw in.
all right. Moving on. People always like to hear stories, particularly juicy war stories. So I just want to throw it out there. You guys have any interesting anecdotes? You can certainly anonymize it as however you see fit, but about breaches or cybersecurity problems that resulted in complicated or messy legal disputes. Anything to share along those lines?
That's what we
Lessons.
talk about with my work on the government side can be discussed.
Yeah, I was just going to add. One thing I'll throw out, since you mentioned I had a long career and I wanted to make sure people didn't think I was actually 100 years old. I got involved in working for NIST in the late 1980s, like 1989. 2 years previous to that was the first major internet security incident. It was called the Internet Security Worm of 1987, and it was launched accidentally, actually by the son of an NSA researcher, and it brought down a large part of what was then the internet. And while it was disruptive, it wasn't nearly as disruptive as if it were to happen today, but a lot of good did flow from that. So I'd emphasize that sometimes these security incidents can result in, much awareness that you didn't have before. From that developed an increased focus on TCP/IP security, but also you saw companies and government agencies and corporations starting up computer security response teams and information being shared. And now there's a common weakness enumeration of common vulnerabilities that you want to make sure aren't in your products or in your programs. So, while I'm in the same boat and I can't really talk about a number of things, there's a lot of pain involved up front, but once you learn your lessons, it can result in much improvement.
So I can add a little bit, similar. I don't have the governmental restrictions. I have kind of ethical confidentiality restrictions, but I would say something that Roselle touched on maybe 10 minutes ago is third-party vendors, whether it's a hosting provider or some other type of MSP. People think, with the cloud, well, I just signed this agreement and now all my data is secure because it's in the cloud, right? I'll use line my boss told. It's someone else's computer, right? So it's amazing how many large events in the past 18 months were caused by a managed service provider who, one employee reused a password or clicked on a phishing email and it impacted thousands of companies. You think about that had notification duties, and they'll be unpacking for years because some are hospitals that used a hosting provider. So I guess my war story would be very careful who you use to host your data, because saving a couple $100 a month or even a couple $1,000 a month in the long term could be significantly expensive. So I guess my war story example would just be that third-party hosting providers, one employee clicked on it and it impacted thousands of entities and it took years to unpack. So be very careful doing your due diligence and touch on, we talked a contract a moment ago, is that make sure they can actually comply with that, right? I mean, there's one thing to sign a contract and in the end you get a month or two's back of your fees, right? Well, when you've just spent tens of thousands of dollars or hundreds of thousands of dollars going through it because you get a $5,000 credit, it's not the best thing. So just make sure that your contracts, that you ensure that you do due diligence and the contracts can actually be complied with by your vendors.
That's a great point. And it sort of leads into the next question. There was our last keynote speaker discussed data ownership and data privacy and data trusts as being a possible emerging solution to the challenges presented by business models that depend on the collection and analysis and monetization of large amounts of data. Most of our data intensive applications that we pay money for collect a lot of their data for free from people who may not necessarily know that their data is being collected and used in that manner. So in your own experiences, just in terms of the data governance issues and data ownership, what are your thoughts on where things are going in that regard, and how does it impact your business and your experiences?
Well, I think it becomes increasingly difficult to understand where data is at any one point because of the complexity in data flows. And so that's an issue that many organizations are trying to tackle now is, okay, I have this PII, but where can it potentially go? And that's a type of issue that Key Caliber tries to address, is understanding where your critical assets are, so you know where that type of data is. But it's just a challenge all around. And unless the security is at the data level, that's an issue that's going to keep coming up and is going to become a bigger and bigger concern, especially if you're dealing with PII or PHI or something along those lines.
Have you seen any specific instances where there was, where you see regulatory pressure or contract requirement pressure for that data level security, or is that still sort of a theoretical, you know this as a data scientist, as a computer scientist, that's really the only way to do it. But do you see any real practical manifestations of that in your business dealings? So yet, I'm sure that's where we're going, or maybe not.
I haven't seen anything on that granular level yet, but there are certainly plenty of requirements around if you have confidential data, and that specifically if that data relates to an individual, then there are many, many safeguards that need to be in place for how you handle that data, which realistically makes sense.
Paul or John, anything to add to that?
I'll just add again to the basics of getting a better handle on why you need to do this and why you need to be concerned about it in the first place is really important. And again, I'll push some of the NIST resources. I do know, like in the elections world, with voter registration data, there's some sensitive information, and voters, are increasingly aware of that and becoming concerned. Some people would like, for example, all cast ballots to be made public, or the electronic cast vote records that are created from scanning the ballots, for those to be made public. And while they are in practically all cases anonymous and you can't trace them back to an individual voter, people are still very aware of that area of privacy, but I find not so aware when it comes to their own data and putting it out on shared drives. So again, I think one of the biggest things is just basic education. Basic education. There's so much to learn, and it is so difficult to figure out where to start and how to get a decent level of understanding so you can understand more. So again, I push for making a concerted effort to just figure out exactly what information security is about.
Yeah, I agree. Kind of the granular details of contracts of how you need to protect that, it's not really there. Generally, both in contracts and in the state law duties, it's if it is subject to unauthorized access or stolen in any way, you need to tell the individual or the entity or the state government. There are some limited exceptions. For example, Massachusetts has a law that requires basically any portable devices to be encrypted, and they enforce that. It is one of the few laws, frankly, that are enforced around the country. Is that if you do have a lost laptop, the AG's office will come after you. There is some granular requirements in HIPAA, but for the most part, we're not there yet.
Sorry, fumbling for the mute. So I think we have time for one more question and one more discussion topic, and then we'll get to questions. So this, I want you guys to speculate here. I'm not looking for any definitive, thing, but we would be remiss talking about the legal aspects of cybersecurity and data if we didn't talk about GDPR in Europe. And I realize that there are not only technical considerations, legal considerations, but there are also political considerations and economic considerations in terms of whether something like GDPR is coming to the United States, if ever. What are your thoughts about that?
Well, I'm certainly no attorney, but I get the impression that California's new law is basically borrowing heavily from GDPR.
GDPR light.
Yeah, so it's already here in the United States, being that the size of the population in California, if that state is requiring something, then that needs to be followed. But yeah, Paul would have better insight on that.
Yeah, no, I think certainly that it was basically the new California law, which I don't know, passed, were voted on by voters last week. We have.
Uh-oh.
I think we lost Paul. Oh, they're getting him back.
Coming back.
John, you want to chime in the meantime?
I'm going to have to pass, unfortunately. I know about the term, but I haven't worked in that area and
Okay.
would defer to Paul. It looks like Paul's
Sorry.
back.
Yeah, I'm back. Sorry about that. So it's certainly the California law is pretty much right up into GDPR. The good news is, at least for implementation, you're looking at least another 3 years until it goes into effect. But the short answer is, I think we will be GDPR kind of up to the doorstep, within 3 to 5 years. That's what we guess. But traditionally, California was the first state that had a notification statute. And then in many ways, other statutes adopted it word for word, and in some cases, including the typos, into their own notification statutes. So I would expect to move in there because it is non-controversial, right? I mean, passing new taxes or other restrictions are people push back, the voters push back, but more secure data, no one's against that. So I definitely think we are going towards a GDPR, though the one distinction is the US more specific on the data elements it protects, whereas GDPR is kind of, you could do harm to an individual. The US to date has been very restrictive of listing the specific data elements at issue.
Okay. So just to summarize, and then we'll get to some questions. It looks like, from our conversation that the drivers of regulations or requirements are a lot of it's based on experiences of the parties involved, but that there are emerging legal standards and statutes, mostly at the state level. Resources for businesses, SANS was mentioned, trade associations, reputable media, and NIST, the National Institute of Standards and Technology. And that business owners can also go to their insurance brokers or the insurance carriers for compliance advice, because that's really, it's in their interest to keep you from screwing up, so that they basically are going to give you assistance with that risk management in the area of cybersecurity. And then the last is that GDPR or something like GDPR is coming, and that that's something also that businesses should familiarize themselves with and start preparing for, because, as Paul said, probably in about 3 years, something like that is going to impact all businesses that touch and handle data. Anything to add to that, guys?
I think you hit it.
That's good for me.
All right.
Sounds good.
So Graham and Janet, what do you got for us in terms of questions?
Well, we have several questions. I will throw it over to Janet to read some of them to you.
All right, great job, guys. Fascinating conversation. I'm going to start with the first question, the one that has the most votes, and that question is, can business owners be personally sued for not putting processes in place to prevent hacking of information? Important question. And I'll throw it out to whoever might have some initial thoughts.
So this is Paul. So I think it really depends on the way you're corporately set up. So I'm sure small business owners, whether you are set up as a corporation or you're a sole business owner or an LLC, it's really going to depend on that. So basically, it's the quote unquote piercing the veil of the corporate. So you're interacting personal. So the short answer is very possible. It really just depends on the corporate structure.
Okay, interesting. Other panelists have ideas on that.
That's why you get errors and omission insurance. Especially, well, so my startup is incorporated. So it's, as Paul mentioned, most of it does not impact me directly per se, but I think it's important for even small companies these days to have E&O, errors and omission insurance, and also cyber insurance. And that's becoming a bigger and bigger area because of the need and importance for it.
Mm-hmm.
Well, we have a great follow-up question to that. Can affordable insurance sufficiently protect small vendors from large clients, or do small biz owners need to lawyer up?
Good question.
So as Laura can start that one again. So I would say to Roselle's point, get cyber insurance, right? Talk to your broker, right? So your broker would have paced your E&O, your property insurance, whatever other insurance you have. So talk to your broker. Candidly, most of my business comes from insurance carriers, so the cost is just extreme if you do have a ransomware event or any other type of event. I mean, you could talk significant costs. So my recommendation, if nothing else come out of this, talk to your broker about getting yourself cyber insurance.
Yeah, and I mean, so I remember reading a stat a number of years ago. Maybe it's changed at this point, but the stat was pretty astonishing. It said something along the lines of 60% of small businesses go out of business within 6 months of having a breach, and I think there are many factors involved as to why that happens, but that's part of why it's just so important to think about it you when you are really small. And even though it does cost some money, you don't want to be in a situation where you're being penny wise and pound foolish at the end of the day.
Interesting. Thank you. So we have mentioned in prior Q&A, we talked a little bit about legal trusts. So this next question is, do legal trusts or co-ops exist for businesses who cannot afford to keep up with the rising legal costs of cybersecurity liability? And Paul, I don't know if this is another one up your alley.
Yeah, I see it much more kind of in the public infrastructure. You know, whether rural states, they'll kind of collectively join together and be part of a co-op or a trust, and that's quite common in the public arena. I have not seen that in the private arena, but certainly I'm sure some smart person will put something like that together because of the rising importance. And the one thing I would say is it's surprising. Cyber insurance, you know, I think underwriting is catching up because of the large kind of ransomware payouts. But if you actually look at the premiums compared to other products, it's surprisingly affordable. Again, it is more money out of your pocket every month, but if you do, and unfortunately, I tell my clients all the time, it's a matter of when. Regardless, you're going to have a cybersecurity event. It could be as simple as a mismailed email. It could be a ransomware event where you have to pay out $1 million ransom. So it's a matter of just doing that, and it is surprisingly affordable when you actually look at the premiums.
And somebody earlier mentioned trade associations as being an important sort of, I guess, a defense for small businesses. Am I interpreting that correctly? Can trade associations on behalf of their members sort of close ranks and help?
That was me, and I referenced it more in terms of a lot of times they will have kind of pre-vetted resources in terms of, you know, where you can go for assistance, and maybe they do, you know, trade associations at times can have, you know, a broker for it, you know, whether it's a small, orthopedic surgeon of northeastern Pennsylvania or something, maybe have that, and the broker knows that type of thing. So that is another way to look at it, because they, if nothing else, will at least have pre-vetted versus you just Googling, you know, cyber insurance.
Right. So, of course, we've had our discussion around healthcare, but we have a question related to that topic. Have there been any successful litigation against healthcare providers for a user's data actually being disclosed or breached, even if from a kind of a major cyber attack?
This might be to me again. I apologize. I think I'm dominating the Q&A. But, you know, so in the healthcare arena, I'd be more concerned about, frankly, the federal government, you know, OCR, which enforces HIPAA, because that is much more active. And they are extremely active, especially when it's over 500 affected. So as a small business owner, I would recommend that would be the one to be more concerned about. The litigation in this arena is like all litigation, unfortunately, in that most of the time it is resolved via settlement. So actually going through the court process, I can't think of one offhand. I'm sure there are out there, but it's much more common to have it just resolved pre-trial, pre-resolution there. But the more active body I'd be more concerned about is Office of Civil Rights.
Okay.
And I'll remind our attendees, if they want to add any more questions to this Q&A, to go to magic.cnf.io. We do have one more question here. Do businesses that store customer credit card info have obligations to protect that data? And if so, what are the penalties if the info is hacked?
Yes, there are absolutely obligations. And again, Paul can talk to the specifics more, but there are PCI standards. And yeah, if you're storing any type of information like that, then you have to have certain controls around it, both from a technical standpoint, as well as from a procedural standpoint, and a physical standpoint as well. But Paul can get into the minutia better than I can. I'm sure.
Yeah, so I think the short answer is don't store customer data or don't store credit card data. I think I recognize you do have a third party. If essential to your business, you have to process credit cards. Generally, it's set up in such a way that it's tokenized, in that it's not ever touching your environment, and that'd be something I'd highly recommend, because, as Roselle said, there are, if you are, by taking Visa, by taking MasterCard, you have an agreement with them, and then your merchant bank, right? So the one that processes the funds and which gets you on the back end, that's going to be a contract. And those are the PCI standards, payment card industry, the PCI standards. And they are very rigorous. And you have to be careful you comply with those. But the short answer is don't save credit card data, because only bad things are going to happen.
Interesting. Good advice.
Yes, and thank you very much to our panel discussion. Dr. Wack, I can throw it back to you if you want to close this out and thank everybody.
We actually did get one other
I'm
question.
sorry.
Yeah, one other question snuck in.
Breaking questions.
So let us take that question that just was submitted. So that question is, how do you see the role of supply chain contracting in ensuring digital rights throughout the ecosystem?
Well, so supply chain contracting is certainly becoming a big issue in the defense industry. So there is now a model that needs to be followed, CMMC, and even for a very small business, it does have to meet a certain standard. The CMMC, generally speaking, from what I understand, is based on the NIST cybersecurity framework. And so there are 5 different levels of standards, and depending on the size of the company, they have to meet that certain level. So they are, I think, at the forefront of codifying how the supply chain is handled. And I wouldn't be surprised if something similar does start to show up in other industries as well.
Interesting. Good question. Thank you. All right, Dr. Wack, we will now throw it back to you.
All right. Well, thank you guys. This was a great panel. Certainly a lot of expertise and some pretty concrete advice for business owners to try to make some sense of the chaos and find their way through the jungle of the business risks of cybersecurity. So thank you very much. And we're off to our next, I guess we had a break. So.
Yes, that's true. We will take a little bit longer than 5 minutes, since we're running slightly ahead of schedule. So we'll be back here at 1:20 for another trivia battle. The next trivia battle topic is risky business. So, if you're not up on your cybersecurity knowledge like you were in the last one, then this might be a better competition for you. So come on back. Be back at 1:20. Thank you.
Thanks.